Good morning, friends. The question for Honorable High Court was if the demand notice under Section 138 of the Negotiable Instrument Act mentioned along with the check amount other amounts also in a separated portion in detail is the demand notes faulty and the complaint can be rejected. So, to know the answer, please see the video till the end. Now, firstly, what is settled law of notice under NI Act? As per Section 138 subclause B of the 1881 NIA Act, the payee or the holder in due course of the check on the dishonor of the check has to make a demand for the payment of said amount of the money by giving notice in writing to the drawer of the check within 30 days of the receipt of information by him from the bank regarding the return of the check unpaid. Now, in the instant case, the applicant, who was Prashant Chandra by name, received a check of rupee 50 lakh from the opposite party. When the same was presented before the bank, it was dishonored because of insufficient funds. Now, as per Section 138 subclause B of the NI Act, the applicant issued a demand notice to the opposite parties calling them to make the payment. Thereafter, when the payment was not made within the stipulated time of 15 days, the applicant moved the court. However, the trial court dismissed his complaint under Section 203 CRPC with a finding that the demand notes served to the accused person was bad in as in the demand notice dated 4th August 2022. There is breakup of the check amount of rupee 50 lakh and another amount of rupee 50 lakh has been mentioned. It was further recorded by the trial court that a demand only for the check amount could have been made and not of the further rupee 50 lakh and interest with quarterly arrests. And as such, the notice issued on behalf of the complainant was not compliant with the provisions of Section 138 subclause B of the Negotiable Instrument Act. However, it was the contention of the applicant that by virtue of provisions contained in Section 138 of the NIA Act, the applicant sought payment of the check amount along with 21% interest with quarterly interest with effect from 5th of October 2022. And hence it was contended that the said amount demand notice cannot be termed as bad in the eyes of law. Challenging the trial court order dated 25th April 2023, the applicant moved the High Court seeking further direction to the court concerned to treat the demand notice as a valid notice of the check amount of rupee 50 lakhs and summon the accused person in accordance with the law and conclude the trial at the earliest. Now, coming to observation of the Honorable High Court. The bench of Justice Shresh Kumar Gupta said that as per settled principle of law, the demand notice should be read as a whole and not consider only part of the notice. And on the demand notice, the holder or payee can demand a payout for the said amount, the check amount. However, the court added when the holder demands other amounts with the check amount, he has to specify that amount with the detail in the notice. And if done so, it does not affect validation of such demand notice. Thus, to make a valid demand notice, as per provision of Section 138B of the Act, the notice should be mentioned in a separate portion of the due amount of the bounce check and other amounts which are additionally claimed, that is, interest of loss cost. In this regard, the court referred to the ruling in the case of Suman Sethi versus Ajay Kumar Chudiwal and another 2000 Volume 2 Supreme Court Case 380, wherein the apex court had held that as per the proviso Clause B to Section 138 of the Act, demand has to be made for the check amount. However, it cannot be faulted if in addition to check amount, any other sum by way of interest cost is separately included. In view of this, the court held that if in the demand notice other amounts are mentioned with the check amount in a separate portion in detail, the said notice cannot be faulted with. With these observations, directions, the application is allowed and the aforesaid impugned order of 25th of April 2023 was set aside. The court also remanded the matter back to the trial court to pass a fresh order after hearing the party. So, I have talked about the case title, that is Prashant Chandra versus State of UP through Principal Secretary Home and other application under section 482 and number is 4587 of 2023, and case citation is 2023 Live Law AB 148. So friends, be careful while giving demand notice of the check amount. Otherwise, if it is faulty, then you have to go through the civil procedure, which is little one, lengthy one. So be careful in demanding through the notice of the amount which has been defaulted by the check issued person. Thanks for watching. God bless you all.